Articles 117 and 118. All it says is that civil or criminal processes coming from any court or place as of Parliament shall not be served on or executed in relation to the Speaker or a member of the Clerk of Parliament while he is on his way to attending at or returning from any proceedings of Parliament. In my respectful view, I do not see Monday in Article 112, 117. I do not see Monday there. I do not see Tuesdays to Friday. I do not see. All that must be understood clearly. Irrespective of that circular, in my respectful view, I, the Attorney General, can, or any citizen of the land, having imposed the decision of the Supreme Court, can serve the process on a member of Parliament, the Speaker of Parliament, or a clerk to Parliament, except when he is on his way to Parliament or returning from Parliament. That's what it says. Again, there is an attempt to suggest, and it was implied in the submissions relating to the Supreme Court overstepping its bounds and whatever, that Parliament of Ghana,
I don't have the right of reply, but it's done over 25 minutes. Let me check.
Attorney General, you have 1 minute.
But I don't have the right to reply, especially that he got up only on points of law. So but he's exceeding.
Please sit down.
Yes, the point of law are many because of application.
Please don't waste your 1 minute.
But the point I'm making is that the Supreme Court's judicial review powers, pursuant to Articles 2 Clause 1 and 130 Clause 1, extend to any authority, institution of state, or any individual in the country. No arm of government, no institution of state, and definitely no individual is exempt from it. Indeed, the President himself is even subject to the Supreme Court's judicial review powers under the Constitution. And the Constitution spells out the consequences for a failure to obey decisions and orders and directives of the Supreme Court. That is in Article 2, Clause 4. Failure to obey or carry out the terms of an order or direction made or given under Clause 2 of this article constitutes a high crime under this Constitution and shall, in the case of the President or Vice President, constitute a ground for removal from office under this Constitution. So clearly, the powers of the court can never be questioned at all. And it is for this reason that the Supreme Court, before an Attorney General and further fortified by J.H. Spencer and Attorney General, reported in 1996 Supreme Court of Ghana law report, stated clearly that in Ghana there's even no such thing as a political person. The court can call into question any act or omission of any person at all, insofar as it's in violation of the Constitution. So the contention by my left friend, Counsel for First Defendants, that it was an administrative decision of the Speaker. And so, with all respect, I'll ask, and so what? Any administrative decision of a person or authority which comes in contravention of the Constitution is amenable to the court's judicial review powers. I certainly submit that the application before you is totally offensive to all rules and procedure of this honorable court, is unknown to the laws of Ghana, and must be dismissed. I appeal accordingly.
Finally, just some short points of law, especially that they were made on points of law, and I'll be very short. First point, that the application is unknown to any rule or procedure and offensive and all of that. First, the simple answer. Since the days of Mosi and Bajina, elementary first rule in the civil procedure class is that if an order is a nullity, you can come by any procedure to set it aside. It remains the law following from that. He likes to cite cases of vintage. He says over 40 years. To calculate when Mosi and Bajina was decided, 1963.
Mr. Sorry, all your juniors are here.
They were here when they said there is a misconception and a misunderstanding. They have remained here. And this is the clearest example of a misconception and misunderstanding. I said from 1963 up to 2000, and we are now in 2020 something. It remains the law, elementary first rule. 2, that I'm challenging the jurisdiction of the courts, and I'm saying with all due respect, some matters don't fall within the jurisdiction.
Some matters do not.
That this matter doesn't fall within the jurisdiction of the court, and that I'm mixing matters that should go through the defense and then an objection.
Now, the point made is that if you are urging that the writ is incompetent, that should be separated from submitting a defense to the substantive action. That's one. Second, that if this court gives an order and you wish for it to be vacated, reversed, varied, discharged, the onus is on you to bring an application under the review jurisdiction of the court, and not an application such as you have crafted. That's the point.
And I'm saying that the tried principle of civil procedure is that the rules of review aside, this court delivers judgment according to three main yardsticks: statute law, common law, and the well-known practice of the courts. That has been consistent. And the well-known practice of the court and the common law is that you come and set it aside. And I'm saying way back from up to date, that remains the law. So this is not a point. Secondly, if I am challenging the jurisdiction of the court, there are two ways and several ways. Elementary civil procedure, I can take it in limine or put it in my defense, and I'm taking it in limine. Another elementary ground. Now, let me just deal with the Article 2.1 point tenderously said, in all of the cases involving Article 99, the jurisdiction of the court to determine a membership of Parliament, they also come under Article 2.1. But the court has always said that yes, if they didn't invoke Article 2.1, they wouldn't have been here. But the court has said, look, we will keep our streams clear. Then you cite to foreign attorney general and about the fact that the matter is within.
Your 1 minute is up.
Well, there are other cases. More recent vintage, they all say clearly that that would not be a reason for the court to entertain jurisdiction. And that's what they said. My Lord, the Chief Justice must have had reason to issue it, and the Speaker must have had reason to respect it.
And it has constitutional power.
If it's not constitutional, he knows what to do. He should come and declare it unconstitutional. But otherwise, then the Speaker should feel deceived by it. That's the point.
You are done.
I'm done. But if my time was happening.
The case is stood down for the court to rule.
All rise.
You're listening to 92.73 FM, and we're coming to you live from the Supreme Court, where you just heard the Chief Justice, Her Ladyship Gertrude Tokono, ask the bench to take a quick recess, where they are going to be ruling, or they're going to be deliberating on the submissions made by the three lawyers, Thaddeus Sori, and then also Mr. Abebio, who is lawyer for the NPP leader in Parliament, Alexander Peñomark, and that was his lawyer who also spoke. And then the final voice we heard was that of the Attorney General, Godfred Dam. Now, these three individuals have made their submissions, and the judges are going into a caucus to go and deliberate and try and argue out the case among themselves. And in the next few minutes, we'll be expecting them to return with a ruling. So what is happening now is that if you are just joining 3FM 92.7, we've been bringing you live coverage of the proceedings in Parliament, where the conversation has actually been the argument has actually been around the fact that The 4 seats that were declared vacant by Speaker Alban Bagbin are back in contention. And the conversation is that the lawyer for the Speaker, Alban Bagbin, has said that the decision of the court to ask the Speaker to stay execution of his ruling, which is that his declaration of the 4 seats vacant, he says the Supreme Court, first of all, did not have the jurisdiction to order the Speaker to revise his position or to hold on to implementing that decision. Secondly, he's asking that he actually asked earlier that Justice Ernest Jewu be asked to recuse himself from the panel, and it was on the back of his affiliation to the New Patriotic Party. The Attorney General in his submission asked that 2 key things be struck out, 2 paragraphs be struck out from the orders of, from the motion that was filed by the Speaker of Parliament, where he's saying that, for instance, paragraph 21 and 49, they had reservations about them, so the Speaker, the Chief Justice and the panel of judges who are sitting over this court should strike out those ones. That was the argument being made by the lawyer for the Republic, that is the Attorney General, lawyer for the government, the Attorney General. So upon a review and consideration, the panel came back and dismissed totally the argument asking for Justice Ernest Jewu or Gaiwu, depending on how you pronounce his name, to recuse himself from the panel. Now the court says that call did not carry enough weight, and so it totally dismissed it. Then after, they came to the substantive issue for the case to be heard. Now 3 lawyers have made their submission. The judges have gone into a caucus. There's a quick recess. And definitely we'll be going back to the House when something concrete comes up or when the judges return from their recess. This is 3FM 92.7. We're taking a quick break. When we come back, we'll be going back to the courts to speak to our correspondents to give us a live update of what has gone on so far, so you can also be aware of where this conversation about the declaration of 4 seats vacant is headed. Stay with us. This is your Election Command Center. We'll be back in a jiffy. 92.73 FM, and we are live from our studio here at Adisawe in Accra. Like I indicated, we've just returned from the Supreme Court, and we'll be headed back there because the 5-member panel led by Chief Justice Gertrude Tokono have taken a quick recess and should be returning shortly to give a ruling on the decision of the court to ask the Speaker of Parliament to hold on to executing his order where he declared 4 seats vacant. Now, the lawyers for the Speaker of Parliament, Thaddeus Sori, and his team have made their submission. The lawyers for the NPP leader, that is Alexander Penyomakin, also made their submission. And the third person to speak was the Attorney General and Minister of Justice, Godfred Dame. They have all made their submissions to the 5-member panel, the judges of the Supreme Court. And as it stands, the issue has actually extended beyond what the judges have said. What the lawyers have said, I should say. And now the judges have taken a quick recess to go and look further into some of the articles and the constitutional provisions that were quoted. And based on that, they will come back and give a ruling. Now, the ruling is going to be two-faced. And like I indicated, we'll go back to the court for a quick update of how all of this is likely to play out. Would the Supreme Court order Parliament to allow the 4 seats that were declared vacant, their members of Parliament, to come back to the House to do parliamentary business? Or they will actually go according to what the Speaker of the House said, which is that those 4 seats have been declared vacant. Either way, we are likely to now have a clear majority in the House. As it stands, there is a contention between the declaration made by the Speaker of Parliament, Alban Bagbin, where he indicates that per the declaration of 4 seats vacant, the NDC becomes the majority of the House? Or would we revert to how Parliament has been since the beginning of this current administration, which is the 8th Parliament, I should say, where the NPP are majority by 1? If that is the status quo, or if that is what we are to go by, then it means that the NPP will retain their majority in the House. And at the next sitting, they may have to sit at the right-hand side of the Speaker. However, as it stands, the House has also, I beg your pardon, Speaker of Parliament also suspended the House sine die, or Parliament has been on suspension indefinitely, and looks as though maybe following today's court ruling, when we get further clarity from the legal perspective of this, the House or the Speaker may be forced to recall Parliament, and when that is done, we'll get a better and clearer understanding of who becomes majority and who becomes minority. But like we indicate, the law lies in the bosom of the judges, and we can only wait to hear what exactly it is that they have to say when they come back in the next few minutes. This is 3FM 92.7. We're bringing you live coverage of the court proceedings. The Supreme Court have been sitting on the subject of whether the declaration of 4 seats vacant by Speaker Bagbin is constitutional or not, and whether that is likely to affect the business of government. Clearly, government business has come to a halt because the submission made from 3 different lawyers, and we are just awaiting for the courts to come back, the judges to come back and give their ruling. Registration and orientation of the Supreme Court, we indicated, after the 5-panel sat and thought through the submissions that were made by Thaddeus Sori, who is lawyer for the Speaker of Parliament, indicated that Justice Jewu will not recuse himself from the panel, citing the fact that he is not the only individual who has served as someone who's worked with a political party or with politicians, and now is sitting or holding a privileged position as a judge of the Supreme Court. And the judges who are sitting on this particular case are the Chief Justice Gertrude Tokonu herself leading this panel. We also have Mariama Owusu, Samuel Asiedu, Ernest Gaiwu, and then also Yao Dakun Asari. So this is the 5-member panel, and Thaddeus Sori, who spoke earlier, also made the argument that he believes that his disposition to having been a political actor in itself subjects him to some scrutiny, and there's a likelihood that it would influence his final decision or verdict that he'll be given on this case. That is why he was asking that he recuse himself. But the courts say they will not agree with that position because it actually has not violated any of the provisions in the Constitution or of the courts. We're going to get to the phone lines now and speak to our correspondents who are following this case for us in court, and it is likely to bring some finality to the argument and the debacle and the back and forth. And very soon we would also try and hear from the judges of the Supreme Court, led by the Chief Justice herself, on what they make of these submissions. Will this bring finality to the argument of whether the Speaker's declaration of 4 seats vacant are unconstitutional? Are they unconstitutional, or they are right within the provisions of our Constitution? And where does the conversation of the separation of powers come in? Does it even come in at all? We will definitely find all of that out in a moment when we get to speak to our correspondents who are following this for us in court. Joseph Akable is our man who's sat through the hearing in court. He's joined us on the phone lines for a quick update. Joseph, thank you for your time. To start with, the judges have gone on recess to do what exactly? What should we be expecting when they return?
So they'll be delivering a ruling on the application that was filed by lawyers for the Speaker of Parliament. And in this particular application, the Speaker of Parliament is asking the court to set aside its October 18 decision. And for context, as we've said, the October 18 decision is the decision that said that, look, the Speaker of Parliament's ruling that the 4 seats have become vacant should not take effect and should be put on hold until this substantive case filed by leader for the MPP caucus and MPP Kutu Alexander Afenyo-Markin is put on hold. And so this is what the court will be ruling on, whether it should set aside its own earlier decision or it should allow its decision to remain in force. And either way, it will have implications, because if the court takes the view that its decision should remain in force, then it means that the current makeup of parliament remains 137 plus 1 for the NPP and 137 on the side of the NDC. On the other hand, if the court sets aside its October 18 decision, then it means that what we revert to the position that the Speaker espoused in declaring those 4 seats vacant, which means that automatically it will leave the NDC with more seats than the MPP in Parliament. And so that is what the court is expected to rule on once a panel presided over by the Chief Justice returns, Martin.
Right. So what exactly were the arguments? So that's just, a summation of what happened in court. But we heard, for instance, the lawyer for Alexander Afenyo-Markin, who was making the point, amongst others, that, first of all, the Speaker shouldn't have even ruled, knowing full well that there was a case that had been sent to the Supreme Court and had Parliament had been duly informed, or at least he, the Speaker, had been duly informed. And the basic aspect of it was that he should have waited as the court interpreted what Article 97 H was about. So what exactly was the thrust of his argument?
And so far, the arguments that have been advanced, so you have the Attorney General and the lawyer for Alexander Afenyo-Markin being on one side, with Thaddeus Sori, the lawyer for the Speaker of Parliament, on the other side. As far as the lawyer for Alexander Afenyo-Markin is concerned, they make the point quite strongly that they came to the Supreme Court simply because in Article 2 of the Constitution, it says that when you believe any person is conducting himself in a manner that is contrary to the Constitution, you also bring the matter up to the Supreme Court for a declaration to that effect. And the Supreme Court also has the mandate to issue such orders to correct the alleged breach of the Constitution if it comes to the conclusion that such a breach has taken place. And so that is their point, that, look, they are taking the view that the matters that were taking place in Parliament with respect to the declaration of the seats being vacant were of a nature that they breach the Constitution. And so they raised the matter and brought it over here to the Supreme Court. And the Supreme Court, they say, has the power to grant any such request, including the decision that it suspended the Speaker's directives. And so they are fortified in their view that the court was within its right. The Attorney General subscribes to this position as well and says that the court has time and again settled and held in various decisions, including decisions from as far back as the late 70s, that this court does not have any limits in terms of its powers, provided an individual who is asking it to exercise a certain power demonstrates that, look, someone has done something that is contrary to the Constitution. Once you're able to meet that threshold, then the court can interfere, whether you are even the president of the land and even Parliament for that matter. And so they do not think that there are any matters that the court is barred from exercising such powers over. And so in terms of the argument on the other side advanced by the Speaker of Parliament, Thaddeus Sori, he says the entire process that has been brought to the court is problematic. He says it's alien to the rules of court. The court ought to have dismissed it. And he even raises questions about the fact that the court had the matter on a Friday, knowing very well that the Parliament is going to sit on a Tuesday. And so he says that due to the gravity of the issues, would have been fair that the court would have heard from the Speaker of Parliament and could have even done so on Monday, even before Tuesday. He again makes the point that, look, the court proceeded to consider matters that were not necessary and were not matters that bordered on suggestions that the parliamentary makeup would be affected, governance would be affected. He says all those are not matters that the court should have heard a single individual to conclude. And so that is his base to say that, look, the Supreme Court was wrong on October 18 and it ought to set aside its decision that suspended the Speaker's directives with regards to the vacancy.
Now, there was a bit about whether or not even the Supreme Court had the jurisdiction to preside over this particular case, where the Speaker was making the argument through his lawyer that this is purely a case for the High Court. How did that come up at all, and how did that end?
He was making the point that the High Court under the laws is allowed in terms of a dispute as to whether a seat has been declared vacant or not. And he makes the point that, look, what has been brought to the Supreme Court attempts to have the Supreme Court answer that question. And they make reference to the fact that what the Speaker of Parliament did was what he's permitted to do under the orders of Parliament and under the Constitution, and that to the effect that where there's a vacancy, the Speaker announces that vacancy, and that is what he did. And so it was not a court order, so to speak, such that is executable. And so those who were following proceedings here on our networks realized that he had said that the speaker's decision was not of executory nature, in that what he had said was a declaration he had declared. And that if you are asking the court to suspend anything, it ought to be another court order, and it does not apply to decisions of Parliament, for instance. And so they are taking the view that, look, those are not matters that the court ought to have entertained, and should they not just dismiss the request that resulted in the suspension, but the entire cases and the documents that have been filed by Alexander Fenyamaki. They want all the entire proceedings struck out completely.
All right, we may have to leave it here for now because we are told that the judges will be returning shortly. We do not know how long they will be on recess for, but definitely when they do come back, Joseph Akable and the team there at the Supreme Court will be joining us for a quick update. Thank you very much, Joseph Akable, who has been helping us at least have a simplified understanding of the proceedings at the Supreme Court, where since about some 2-3 hours ago, the judges have been sitting, listening to the lawyers of the various parties to this case. I'm talking about the Speaker of Parliament's lawyer, the lawyer for the NPP leader in Parliament, Alexander Fenyamaki, and the Attorney General, who have all made submissions to the judges regarding the Speaker's decision to declare 4 seats vacant. Now, that has actually thrown the entire country into trying to understand what this even means going into the elections, what it means for the political parties, what it means for the members of Parliament themselves, and whether or not when they return, when Parliament is recalled, these individuals will return to the House. All of that is expected in the final orders of the courts, the Supreme Court. Will it be binding? Will it be binding on the on the Parliament of Ghana? Certainly, because when a particular issue or law has to do with interpretation, or there is a confusion about any law, the only institution with the mandate to interpret will be the Supreme Court. So this falls right on their lap to interpret what Article 97 H and its attendant provisions mean. However, some lawyers have argued that it is plain English and that it did not need to even go to the Supreme Court. But it has gone there, they've deliberated on it, they've argued and given counter-arguments. We will only have to wait to hear what the leadership of the Supreme Court or the judges of the courts will come and say. This is your Election Command Center. If they do